Hello, welcome to my channel. And today I'm going to talk specifically to maybe lawyers and a bit to clients, people who get to buy properties, real estate investors, because sometimes your lawyer a lawyer is human. He certainly cannot know everything. There is no perfect lawyer, right? And his mind may not just avert to certain things, right? Anyway, he's a professional, right? And he's supposed to know stuff really. But just maybe you should also be aware of certain things when you are buying a property, right? You shouldn't entirely just be a novice, except you're carrying someone who would represent your interest properly, right? So factors, two key factors that every lawyer must pay attention to when preparing a title document, or two key factors that every client must look out for in his or her title document when such is being prepared by a lawyer. And on that note, I'd like to introduce myself as Raymond Ijeomah, a real estate entrepreneur as well as a property lawyer here in Nigeria. And here, let's go right into the conversation. So, what are the factors to consider? Number one, the most number one is proper parties. Proper parties. When you are preparing a title document as a lawyer, or when you are buying a property, you should ensure that the persons transacting are proper parties. The persons transacting are proper parties. And by proper parties, I would separate that into individual proper party as well as corporate proper party. And let me explain that. Someone is a proper party when, number one, the person possesses the competence. Okay, no, I'll explain that in the second point, but let me just focus on the independent right or propriety to carry out a particular real estate transaction. So, proper party in the context of this video would be that the person is right in the eye of the law to carry out that transaction. So for instance, can a minor ordinarily transact in a property? Generally, the answer is no. So if a minor is transacting in a particular real estate or property transaction and certain there is no established exception to that effect as per while, maybe it's not buying through somebody or through a power of attorney or something, or through a medium that empowers the minor to buy, or someone buying by way of a proxy, then that is not a proper party, and that transaction will be affected by the impropriety of that particular party. Number two, on the basis of an individual transaction, maybe the person is not sane. Can the same person transfer interest? Logically, the answer is no. The person doesn't understand what he or she is doing at that particular point in time. So maybe you are a client and you're looking at someone buying a property or someone trying to sell a property, and you sense very strongly that something is wrong with this person. Then you have to pause and really look into what is going on. Okay, but majorly, these are just the minor part. Majorly, when you look at the angle to corporate entities, some corporate bodies, I would use corporate bodies so that I would put it in proper context. Some organizations claim that they are registered. If they are not registered and they want to transact in the name of that, for instance, ABC Company Limited, then it is not a proper party. Because in the eye of the law, it is not a legal entity until it is deemed a legal entity by virtue of registration with the company's CAC, Corporate Affairs Commission, under the Companies and Allied Matters Act, then such organization that is acclaimed to be a corporate entity will not in that instant be a proper party. So how do you find out if a company is registered? We already talked about it, myself and Jeff knows it in one of our videos extensively. How do you know if the company is a property? Go to CAC website, carry out the search, just type the name of the company under the search angle for corporate entities, and then you find out if the company is registered. You could also go deeper to find out, make a payment and go deeper and find out if the people who are transacting within the company, right? And with that, you are able to determine whether this company is registered and it's a proper party and can, on the basis of that propriety, transfer title or transact in real estate, right? So you really want to find out if a person is a proper, because of course a company, a registered company, is a person in the eye of the law, right? So if the company is not properly registered, then it cannot be considered as a person in the eye of the law, and as such cannot transfer title or cannot transact with respect to real estate as a normal human being would. Okay, so you're preparing a title document, you really want to look out for that, and that also extends to proper parties as to an illiterate or a blind person. If you are transacting with such persons, then there's a condition attached. You have to prepare an illiterate jurat or a blind person jurat alongside the title document. Most persons don't know this, and one of the prima facie indications of whether someone is illiterate is if you use thumbprint on the title document. So the moment you see a title document where there's a thumbprint, it is safe to assume that the person is an illiterate, and then you have to prepare an illiterate jurat for the person to now transfer title to you, right? It is not a strict legal condition to propriety, but it sends a message as per evidence, strength of evidence, right? So proper party as to individuality and proper party as to the corporate entity. That there are two factors you must consider. And then talking about a business name or corporate entities now, a business name registered as a business is not a corporate entity and not a proper party to carry out a land transaction. If it is registered as a business name under the with the Corporate Affairs Commission, it is registered as a business name. Do you understand what I mean by a business as just as a venture and not a limited liability company? Then it should not use its company name, its business name to transact. Rather, it can transact in the name of the founder or the person in charge of the business or the company, in quotes, under the name and style of ABC Solutions or ABC whatever, or the name of the business. And as such, it is transacting in the name of an individual working as in a capacity representing a business name, a business. But really, it is entirely wrong to transact exclusively with the name of that business. I don't know if you understand me. The difference is, one is registered as a business name, maybe Raymond Ventures, and the other one is registered as Fortreal Rei Ltd. Only a limited liability company can transact in his name. Only a registered church can transact. That reminds me. I remember I visited one of my uncles during the Yuletide, and we were having a conversation about church buying properties, and one of the members asked him who he was a pastor in the church, of a branch of the church, and the member asked him, these properties we are buying, who is the owner? And then he responded and said that it's for the church. And then I asked him a question: is the church registered? And he said no, that they usually buy it in the name of the pastor, buy the name of the church rather than the pastor signs. And I'm like, okay, there's a big issue here. The church is not a registered entity. And this church I know of is a very big church, massive church, with branches in about 4 to 5 different locations. Sadly, it is not registered, and it doesn't have the capacity to use that church name to buy a property or to transact as far as real estate is concerned. And there's another problem on the other side of it, because if it eventually buys in the name of the pastor, his children can wake up tomorrow and lay claim on those property and may succeed. Quite complicated, right? But that's it. It is what it is. You want to transact with only a registered limited liability company, a registered NGO, foundation, generally under Part C of Kama, a registered church. Those are entities that possess the right, the proper party status to transact in real estate. So if you are dealing with any of these entities, you really want to pay attention to the propriety or the properness of such parties, so that you do not want to get into, so that you don't get into transactions that end up becoming an issue tomorrow. And then secondly, you want to find out the propriety of the parties involved in the transaction as per the authority or the competence to sell. And by that I mean, does the person selling have the right to sell? Does the person selling have the right to sell? So your duty is not just to say. I remember, I think I've told this story in one of my videos of how a colleague of mine expressly told me that the genuineness of the property is not my concern. My own is to do agreement. That was his phrase. And in that transaction, at the end of the day, it was discovered that the person who was selling did not possess the capacity to sell. So whilst preparing a title document as a lawyer, this is me encouraging that you pay attention to the person's authority or competence to sell. So basically 2 things. Is the person legally competent to transact real estate generally? And then secondly, does the person possess the right to sell to you in that particular transaction? And then on that note, I come to the end of today's episode. And again, my name is Raymond Ijeomah, and I'm a real estate entrepreneur as well as a property lawyer here in Nigeria. If you haven't subscribed to this video, do it, subscribe, because more of this and better stuff are coming your way right on this channel. And of course, you can also share with your friend, because information, knowledge is power. And on that note, we will wrap it up and say bye-bye.